2. The death penalty. A man will act on his faith, and, if his faith be humanistic, inevitably his basic standard will be man, not God's law. He will view the world not as God's handiwork, but as his own. A theologian of the Death of God school, William Hamilton, has called attention to the fact that man now rarely looks at the starry sky with a sense of reverence for God. Instead, he cites his experience with his son as illustrative of a new attitude. The other night I was out in the backyard with one of my children, who had to identify some constellations for his science homework. My son is a full citizen of the modern world, and said to me, after he had located the required constellations, "Which are the ones we put up there, Dad?" He had become a technological man, and this means something religiously. The boy's reaction was clearly logical. If the God of Scripture does not exist, then man is his own God and the world's Lord and Maker. Moreover, if man is his own God, then man and man's life are the highest value. The greatest sin then becomes the taking of life. Accordingly, Arthur Miller, the dramatist, declares that life is God's most precious gift. No principle, however glorious, may justify the taking of it. It follows from such a faith that the worst kind of sin is capital punishment, the deliberate taking of life by the state. This was precisely the point made by an editorial in the New York Herald Tribune, May 3, 1960. A barbarous form of punishment, protesting the execution of Carol Chessman. Chessman succeeded in making himself a worldwide symbol of the fight against the death penalty. He may or may not have been guilty 12 years ago of robbery and sexual assault, called kidnapping by a strange quirk of California law. The courts found him guilty. To the end he maintained his innocence, and the germ of doubt thus left will continue to cloud the case. But certainly the man killed yesterday by the sovereign state of California was not the same man whom that state's courts originally sentenced. California sentenced a young thug. It killed a man who had learned the law and probably citizenship the hard way. The law should inculcate respect for life by itself respecting the sanctity of life. The state should not, as California did yesterday, put itself in the position of the errant father telling his wayward son, "Do as I say, not as I do." Death is final. It leaves no room for second thoughts or for correction of the errors that are a mathematical certainty in a system of justice based on fallible human judgment. And the quintessential premeditation which judicial killing represents makes it more coldly vicious than a crime of passion. The very concept of a death chamber is antithetical to the ideals of Western civilization. In terms of such a faith, the most vicious people of all are those who favor the death penalty. By their offense against man, they commit the unpardonable sin for humanism. In order to give man the preeminence, the humanist logically must destroy any concept of justice as a real and objective standard. Man must be above law, and therefore above justice. Justice is therefore reduced to rationalization and organized hatred. Thus, a University of Leicester sociologist has written of justice. But could all this instead perhaps be some kind of historical confidence trick? It has already been suggested that our idea of justice may be a rationalization of what is at bottom punitive behavior. This would not be to argue that the idea of justice is a fake, but rather that instead of taking it at face value, we might try to understand what needs it is intended to satisfy. It may appear, then, as a kind of collective psychological defense. As proof of the validity of our ideals, we are often inclined to refer to the sense of conviction that we and other people possess about them. Most of us certainly have strong convictions about the rightness of the ideal of justice, but all that a sense of conviction does is to prove its appropriateness for us. That in the present state of our emotional economy, such a belief has, for us, a very special and much needed part to play. But justice, seen in this light, is not merely the solvent of unrest within us, it is a positive outlet through which these tensions can be discharged in, as it seems to us, a constructive fashion. Through the idea of justice, the bad things within us are transformed into something new and worthwhile. All this so long as we do not look too closely at the outcome. For, to stand the famous phrase upon its head, and thus perhaps give it more validity, justice may often, manifestly appear to be done than to be done in fact. Justice William O. Douglas has pointed out the obvious fact that law once had a divine sanction and rested on God's will. Now, however, the sovereignty of God has been replaced by the sovereignty of the individual. In terms of this, for Douglas, the civil liberties struggle is of necessity hostile to the old order. Indeed, law and order is the guiding star of the totalitarians, not of free men. For Douglas, revolution is therefore basic in the rights of man, and naturally so, since man is above the law, and submission to the law is tyranny. In a, quote, decent society, there is respect for and effort to preserve the sovereignty and honour, as well as the dignity of each and every individual. In the anarchistic world of Douglas, what law can bind man who is above the law? And what state can survive if free men are those who are hostile to law and order? Clearly, a religious war is in process between humanism and Christianity, and in that war, church, state, and school are almost wholly on the side of humanism as against Christianity. But history has never been determined by majorities, but rather always and only by God. The struggle is between God's absolute justice and his law order, and man's lawless self-assertion and autonomy. God's law order requires the death penalty for capital offences against that realm. Man's law claims to value life too highly to take it, but humanistic societies do exact death for those whom they deem to be their enemies. The death penalty appears at the onset of God's covenant with Noah. And surely your blood of your lives will I require, at the hand of every beast I will require it, and at the hand of man, at the hand of every man's beast will I require the life of man. Whoso sheddeth man's blood, by man shall his blood be shed. For in the image of God made he him. Genesis chapter 9, verses 5 and 6. Not only every murderer, but every animal which kills a man must pay with its life. God requires this of a country and brings judgment finally for non-compliance. As Rand noted, contrary to popular belief, the Bible does not hold life cheaply. It is a serious thing to take life, and for the taking of life, the murderer forfeits his life. For this reason, there can be no ransoming or pardoning of murder, as distinguished from accidental killing, nor a ransom taken, for to do so is to defile the land where God dwells in the midst of his people. Numbers chapter 35, verses 29 to 34. In terms of biblical law, the required modes of punishment, as summarized by Rand, were as follows. 1. The death penalty for capital offences. 2. Whipping from 1 to 40 stripes for minor offences. 3. In cases of stealing and destruction of another man's property, restitution, to which must be added from 100 to 400% as punishment. 4. Those who were financially unable to make restitution or pay the fine were compelled to contribute their work and labour until the debt had been fully paid. 5. Confinement in a city of refuge for accidental killing. The replacement of this system by imprisonment is relatively recent. As late as 1771, a French criminologist wrote that imprisonment was permissible only in the case of people awaiting trial. But today, prison is all there is. The death penalty is out of fashion. Only one man was executed for crime in the United States after legal process in 1966. The prison system, a humanistic device, is now under attack by the humanists who want to replace it with a mental institution and psychiatric retraining. However, since their theory holds that it is a sick society which breeds sick men or criminals, the major attempt is to have psychological reconditioning or brainwashing of all people by means of the schools, pulpit, press, and television. Humanistic environmentalism requires such an approach. Marxism, as a more rigorous form of environmentalism, is dedicated to a total remaking of the social environment. This humanistic environmentalism is a form of the same basic evolutionary faith which was formulated by Lamarck. Man can be and is determined by his environment and by acquired characteristics, rather than by his inner being. Not man's sin, but the world around him determines man's will. Thus, the Marxist Lincoln Steffens, in referring to man's fall, blamed not Adam nor Eve nor the serpent. It is the apple. That is, the environment, the world man lives in. From such a perspective, it is wrong to blame man. It is the world which must be remade by man to be fit for man. To punish man is thus seen as evil. It is God who made the world, and the men who, under God, established God's law order, who must be punished. Thus, between biblical law and humanistic law, there is an unbridgeable gap and an unceasing warfare. The principle involved in the biblical law of punishment is stated in Exodus chapter 21, verses 23 to 25. Thou shalt give life for life, eye for eye, tooth for tooth, hand for hand, foot for foot. burning for burning, wound for wound, stripe for stripe. Some choose to interpret this literally, but the very context, Exodus chapter 21 verses 1 to 36, a delineation of offences and penalties, makes it clear that it means that the punishment must fit the crime. It must be proportionate to the offence, neither lesser nor greater. This principle is restated in Leviticus chapter 24 verses 17 to 21 and Deuteronomy chapter 19 verse 21. The comment of Euler is of interest. The Mosaic principle of punishment is the jus talionis, as it is repeatedly expressed in the sentence, life for life, eye for eye, tooth for tooth, etc. Exodus chapter 21 verses 23 to 25, Leviticus chapter 24 verses 18 following, Deuteronomy chapter 19 verse 21. It shall be done to him who has offended as he has done. In other words, the punishment is a retribution corresponding in quantity and quality to the wicked deed. By this, the talio is not meant to be understood in a merely external sense, is not only shown by various provisions of punishment, but by the fact that not simply the deed itself, but the guilt lying at the root of the deed is often taken into account in determining the punishment. The punishment of death is attached apparently to a large number of crimes. It is prescribed not only for the crime of murder, maltreatment of parents, man-stealing, Exodus chapter 21 verses 12 following, adultery, incest and other unnatural crimes, idolatry, and the practice of heathen divination and witchcraft, Leviticus chapter 20, Deuteronomy chapter 13 verses 6 following, but for overstepping certain fundamental ordinances of the theocracy, the law of circumcision, Genesis chapter 17 verse 14, the law of the Passover, Exodus chapter 12 verses 15 and 19, the Sabbath law, chapter 31 verse 14 following, the pollution of sacrifices, Leviticus chapter 7 verse 20 following, sacrificing at other places than the sanctuary, chapter 17 verse 8 following, certain laws of purification, chapter 22 verse 2, Numbers chapter 19 verses 13 and 20. Yet the peculiar expression, to be cut off from the people, is chosen for the punishment of transgressions of the latter class, in distinction from the former, an expression which, indeed, cannot refer to simple banishment, as some have interpreted it, but still, in some cases, seems to point to a punishment to be executed, not by human judgment, but by the divine power. What is said in Leviticus chapter 17 verse 10 with reference to the person who eats blood, I will blot out that person. When the punishment was really to be executed by human judgment, the term, he shall be put to death, is used, as of the violation of the Sabbath law, Exodus chapter 31 verse 14, and in the passages of the former kind, Exodus chapter 21 verses 12 following, Leviticus chapter 20, etc. In general, in all cases where the people did not execute judgment on the transgressor, Jehovah himself reserves the exercise of justice to himself. See as main passage, Leviticus chapter 20, verses 4 to 6. There are thus two kinds of capital punishment. First, God directly executes judgment and death upon men and nations for certain offences. This he does at his time and will, and none can say him nay. Second, God delegates to man the duty of inflicting death for certain offences, and that's without undue delay and without hesitation. In examining the obligation of man to inflict the death penalty, we see first that, normally, no ransom or fine could be paid for murder to release the guilty. As Numbers chapter 35 verse 31 declared, "Moreover, ye shall take no satisfaction for the life of a murderer, which is guilty of death, but he shall be surely put to death." The one exception to this is in cases where an ox, with a record of goring, kills a man. The owner, then, shall be put to death, unless there be laid on him a sum of money, and he shall give for the ransom of his life whatsoever is laid upon him. Exodus chapter 21, verses 29 and 30. In such cases, because the ox is the primary murderer, there is a possibility of escape for the owner. Second, as appears in the case of the goring ox, biblical law holds animals as well as men liable for murder charges. This clearly appears in Genesis chapter 9 verse 5, as well as in the law. If a man owns an animal, and the animal kills a man, the animal dies. The owner is not guilty if the animal has no previous record of unprovoked violence. Exodus chapter 21 verse 28. But if the animal had a record of violence in the past, then the owner is liable for murder charges and capital punishment. For a freeman, ransom was possible. With slaves, the ransom is specified by law, 30 shekels of silver, to prevent undue ransom being required for a slave as the alternative to death. Exodus chapter 21, verses 29 to 32. An offence by an ox against another man's ox is also guilty before the law and liable. If the criminal animal had no previous record, then it must be sold and the proceeds divided between the two owners, and the killed ox is also sold and the proceeds divided. But if the criminal ox had a record of misconduct, then it is sold and the proceeds given entirely to the owner of the dead ox, who retains possession of the proceeds of the dead ox. Exodus chapter 21, verses 35 and 36. This principle of animal liability and the liability of their owners is still a part of our law. If the executed ox was killed by stoning, its flesh could not be eaten, having not been bled. Exodus chapter 21, verse 28. A strange modern application or misapplication of this law appears in a modernist commentary. The animals that kill men today are not oxen, but tiny organisms, germs of disease. If the possessors of these are careless in spreading them around, they too should be put to death, or charged a very high ransom. Third, we have seen that the principle is life for life, that is, a punishment proportionate to the crime. This crime has no reference to the criminal or his mentality, but only to the nature of the act. If death is a penalty for animals on the principle of life for life, then this is certainly true for men. Thus, on this principle, biblical law has no plea of not guilty by reason of insanity. Neither is there any privileged status before the law for a minor. Murder requires the death penalty, whether the offender is an animal, an insane man, a child, or a feeble-minded person. The modern plea of not guilty by reason of insanity arose in 1843 in the trial of Daniel Macnaghten for the murder of Edward Drummond, secretary to Sir Robert Peel. As a result of Macnaghten's trial, the Macnaghten rules were developed. It was A. presumed that every man is sane until the contrary is proved, but B. a man who was insane or labouring under a defect of reason while committing the act, so that he did not realise the nature of the act or its wrongness, was not guilty by reason of insanity. Macnaghten was committed to an asylum instead of being executed. The Macnaghten rules led to the decision in 1954 by David T. Bazelon of the Court of Appeals for the District of Columbia that no one could be held criminally responsible if his unlawful act was a product of mental disease or mental defect. This was the Durham case, the trial of Monty Durham, a housebreaker and check passer who had been in and out of jails and mental hospitals for 7 of his 24 years. Such pleas as the Macnaghten and Durham rules permit the courts to set aside the life-for-life principle, the principle of justice and justice itself, in favour of a humanistic concern for the life of the criminal. Supposedly, prisons are punitive and heartless compared to mental treatment. But, as Mayer has noted, the most cursory look at our institutions reveals that some prisons in Wisconsin, in California, and in the federal system are in fact much less punitive than the ordinary state mental hospital. And a man is not likely to be much better off in the job market later if his record shows a civil commitment to an institution for the criminally insane rather than a conviction for a crime. The prison system is a humanistic device, an ostensibly more humane way of treatment than the older biblical law required. Now, the mental health approach is supposedly even more humane, when, in actuality, as Solomon long ago noted, that here, as elsewhere, the tender mercies of the wicked are cruel. Proverbs chapter 12, verse 10. But we are told by psychiatrists like Menninger that society can be made healthy only by replacing the punitive attitude with a therapeutic attitude. To demand punishment of criminals is to reveal our own mental sickness. He speaks of it, in fact, as the crime of punishment, so that, in his eyes, the good people of society are all criminals when they demand punishment. Menninger holds that the crime of society against the criminal is greater than that of the criminal against society. I suspect that all the crimes committed by all the jailed criminals do not equal in total social damage that of the crimes committed against them. Of the criminal, Menninger says, "We need criminals to identify ourselves with, to envy secretly, and to punish stoutly. They do for us the forbidden, illegal things we wish to do, and, like scapegoats of old, they bear the burdens of our displaced guilt and punishments, the iniquities of us all." As a humanist, Menninger regards man's life as the greatest good, and any injury to life as the greatest evil. The great sin by which we are all tempted is the wish to hurt others, and this sin must be avoided if we are to live and let live. Similar opinions are to be found in the legal profession, and in fact dominate it. This was apparent in the 1968 convention of the American Bar Association, ABA. The kind of thinking which appealed to many was definitely to the left, and was all humanistic. Thus, a Negro lawyer, William Coleman of Philadelphia, argued that society should be prepared to sanction a certain amount of unrest and inconvenience as a price of progress. He contended that persons engaged in civil disobedience should be paid for their trouble in fighting unjust laws. When a cause is worthy, agreed Louis H. Pollock, dean of Yale Law School, prosecutors should refuse to press charges against persons engaged in civil disobedience. He did not set forth specific guidelines for determining whether a cause is worthy. Of course, rioters were already being extensively subsidized in their civil disobedience and rioting, as numerous studies and reports have demonstrated, federal grants being generously given. There was a dissenting voice at the ABA convention, a guest, Lord Justice Widgery of the Court of Appeals in England. After listening to conferences on crime and civil disorder for 5 days, the British jurist said it had struck me very forcibly that I have heard not one word of commendation or criticism of the police, the shock troops in the fight against crime. How do lawyers and judges expect to keep the peace, he said, unless they have an efficient police force? The Lord Justice also questioned the dictum expressed moments earlier by Attorney General Clark that poverty is the mother of crime. Lord Justice Widgery dryly advised his audience not to attach too much importance to this theory. Anyone who thinks relief of poverty will bring a decrease in crime is in for some kind of disappointment, he said. The greatest part of England's slums, he said, were razed by World War II bombing, so poor housing is no excuse for crime. And Britain has had very great success with its Robin Hood fiscal policy of taking from the rich and giving to the poor, and you would think there would be a drop in the crime figures. But nothing like this has happened. There's been an increase in every department. Among the poor, the middle class and the well-to-do. Crime and civil disorder continue to increase, he suggests, because societies throughout the Western world have lost discipline, acceptance by its members of a code of discipline. In 1968, the Attorney General of the United States, Ramsey Clark, quoted the Fabian socialist, George Bernard Shaw, that murder and capital punishments are not opposites that cancel one another, but similars that breed their kind. Urged Congress to abolish capital punishment for federal crimes. According to Clark's testimony before a Senate subcommittee, in the midst of anxiety and fear, complexity and doubt, perhaps our greatest need is reverence for life, mere life, our lives, the lives of others, all life. A humane and generous concern for every individual, for his safety, his health and his fulfillment will do more to soothe this savage heart than the fear of state-inflicted death, which chiefly serve to remind us how close we remain to the jungle. The courts today, moving in terms of humanistic law, are already hostile to law and order. As Gardner has pointed out, the rights of the individual are being protected, provided the individual has committed the crime. The concern for the criminal has reached the point where prison chaplains in Germany have formed a labour union for convicts, and West Germany has given the union a charter. To return to the insanity plea, some cities already have a separate psychiatric court, as witnessed Los Angeles, to which many cases are referred. The court handles all cases involving mental illnesses, including court commitments of persons to mental hospitals, civil and criminal narcotics cases, and determinations for the municipal courts on questions of criminal insanity. The move to abolish the death penalty substitutes medicine for morals, and it denies the legal doctrine of individual responsibility, one of the fundamentals of godly law. The door to pagan savagery is opened by this psychiatric approach. Instead of individual responsibility, guilt and punishment, group responsibility, guilt and punishment is stressed. The society at large and the family get the blame, not the criminal. The time is drawing closer when it will be dangerous to be innocent of crime, because innocence will constitute the greatest guilt. This is already the belief of the civil rights revolutionists. Already, the defense in one court case indicates the direction of the law. A convicted rapist who entered a belated plea of innocent by reason of insanity has been defended in court on two grounds. A. He has an abnormal chromosome makeup, and B. He felt rejected by women. In fact, Menninger has declared, "The unconscious fear of women goads some men with a compulsive urge to conquer, humiliate, hurt, or render powerless some available sample of womanhood." The rapist is not guilty. His fears and perhaps his chromosomes also drive him to rape. Menninger has made clear his belief in the guilt of the innocent. The criminal is not responsible, he is driven by society to crime. Thus, as a Mrs. John Connolly of St. Paul, Minnesota, said of Sirhan Bishara Sirhan when his trial for the murder of Senator Robert F. Kennedy began, "I think this poor fellow Sirhan is a very sad creature. It's hard to imagine anyone who would be driven to something like this." If Sirhan and other criminals are driven men, then someone did the driving and is therefore guilty. And if the criminal is predetermined to crime by his environment, the humanists, by asserting this, have substituted determinism by the environment for predestination by God. Fourth, the death penalty is required by Scripture for a number of offences. These are for 1. Murder, but not for accidental killing. Exodus chapter 2, verses 12 to 14. 2. Striking or cursing a parent. Exodus chapter 21, verse 15. Leviticus chapter 20, verse 9. Proverbs chapter 20, verse 20. Matthew chapter 15, verse 4. Mark chapter 7, verse 10. It should be noted that Christ condemned the scribes and Pharisees for setting aside this law. 3. Kidnapping. Exodus chapter 21, verse 16. Deuteronomy chapter 24, verse 7. 4. Adultery. Leviticus chapter 20, verses 10 to 21. To be discussed later. 5. Incest. Leviticus chapter 20, verses 11 and 12 and 14. 6. Bestiality. Exodus chapter 22, verse 19. Leviticus chapter 20, verses 15 and 16. 7. Sodomy or homosexuality. Leviticus chapter 20, verse 13. 8. Unchastity. Deuteronomy chapter 22, verses 20 and 21. To be discussed later. 9. Rape of a betrothed virgin. Deuteronomy chapter 22, verses 23 to 27. 10. Witchcraft. Exodus chapter 22, verse 18. 11. Offering human sacrifice. Leviticus chapter 20, verse 2. 12. Incorrigible delinquency or habitual criminality. Deuteronomy chapter 21, verses 18 to 21. 13. Blasphemy. Leviticus chapter 24, verses 11 to 14, verse 16 and verse 23. Already discussed earlier. 14. Sabbath desecration. Exodus chapter 35, verse 2, Numbers chapter 15, verses 32 to 36, already discussed earlier, now superseded. 15. Propagation of false doctrines. Deuteronomy chapter 13, verses 1 to 10, also discussed earlier. 16. Sacrificing to false gods. Exodus chapter 22, verse 20. 17. Refusing to abide by the court decision and thus denying the law. Deuteronomy chapter 17, verses 8 to 13. 18. Failing to restore the pledge or bailment. Exodus chapter 18, verses 12 and 13. Because such an act destroyed the possibility of community trust and association. The methods of capital punishment were by burning, Leviticus chapter 20, verse 14, chapter 21, verse 9, stoning, Leviticus chapter 20, verse 2 and verse 27, chapter 24, verse 14, Deuteronomy chapter 21, verse 21, hanging, Deuteronomy chapter 21, verses 22 and 23, Joshua chapter 8, verse 29, and the sword, Exodus chapter 32, verses 27 and 28. The use of the sword was an exceptional circumstance, and the basic requirement in every case was the death penalty itself, rather than the form of the penalty. Moreover, as Carey has pointed out, capital punishment was never to be inflicted on the testimony of less than 2 witnesses. Numbers chapter 35, verse 30, Deuteronomy chapter 17, verse 6, Deuteronomy chapter 19, verse 15. In specified instances, capital punishment was to be executed by the witnesses themselves, as in Deuteronomy chapter 13, verses 6 to 10, and chapter 17, verse 7. In some instances, execution was by the congregation, Numbers chapter 15, verses 32 to 36, Deuteronomy chapter 13, verses 6 to 10, or by nearest of kin, the avenger of blood, Deuteronomy chapter 19, verses 11 and 12. For the humanist mind, these penalties seem severe and unnecessary. In actuality, the penalties, together with the biblical faith which motivated them, worked to reduce crime. Thus, when New England passed laws requiring the death penalty for incorrigible delinquents and for children who struck their parents, no executions were necessary. The law kept children in line. Some laws secure their desired effect without any necessity for prosecution. Thus, to cite one instance from the 1920s, as described by Llewellyn, the books of the New York Public Library persisted in disappearing. This was a field peculiarly of juvenile delinquency. The opportunity was open to all, but the rewards of theft so petty as to make juveniles the likely prospects. A statute was passed making exhibition for sale of a book bearing the library stamp an offence. The library officials saw to it that every second-hand book dealer in the city received notice of this statute. Promptly, the thefts decreased almost into nothingness. The market had become unprofitable. There has never been a prosecution under the law. There is no need. This is not always the case, for when the religious and moral character of a people disintegrate, the lawbreakers begin to outnumber the police and the law keepers. Biblical law eliminates the incorrigible and habitual criminals. Biblical faith gives to the people a godly character and a law-abiding disposition. The breakdown of humanistic law orders is due to the radical criminal disposition of its lawless peoples. In spite of all the extensive pity for criminals, the fact remains that 80% of all accused persons plead guilty. Some of the remaining 20% are guilty, but the complaining party has dropped the charges. Mayer notes of these that many are like our young man whose girl decided she wanted him even though he had beaten her to a pulp. To speed up the legal logjam, many guilty parties are allowed to plead guilty to a lesser charge to avoid delay and expense. Other studies show of every 100 picked up by the police, as against those formally accused, 50 are convicted on the guilty plea, 5 are convicted after trial, 30 are released without charges being brought, 13 are released by administrative process after arraignment but before trial, and 2 are acquitted after trial. Thus, while in any fallible human system mistakes are made, they are obviously not very common. Justice has rough edges, but there is no alternative to justice. Moreover, as Mayer noted of New York's criminal courts, lawyers never wear hats. Because if you put a hat down anywhere in a criminal court building, someone steals it. Moreover, criminal practice is the one branch of the law where lawyers collect their fee in advance. The reason, of course, is the radical dishonesty of their clients. But more important is the situation with respect to juveniles. According to the FBI Uniform Crime Reports, 48% of all arrests for serious offences in 1964 were arrests of children under the age of 18, and 43.3% of all those formally charged with serious crimes by the police were referred to the juvenile court for disposition. The peak comes at age 15. Generally speaking, incidentally, the larger the city, the smaller the proportion of those under 18 in the total number of arrests. It has been estimated that 1/9 of the nation's children, 1/6 of the boys, make some contact with a juvenile court, usually for a quite minor offence, between the ages of 10 and 17. The figures after 1964 grew markedly worse. Too many of the children not involved in the juvenile courts are also schooled in lawlessness by humanistic education and religion. The result is the policeman's impossible task. In Berkeley on a Saturday night, there may be 2,000 pot parties going on. Can you have an informer or a policeman at each one? The law breaks down when the faith behind the law is gone. The hostility to the death penalty is humanism's hostility to God's law. But God's government prevails, and his alternatives are clear-cut. Either men and nations obey his laws, or God invokes his death penalty against them. We have cited above the high ratio of guilt in all indicted persons. This does not mean that innocent men are not sometimes condemned. The Dudley Boyle case appears to have been such a case. Dudley Boyle, a mining engineer and a high-spirited young man, was arrested during the Depression for robbing the Bank of Sparks. He was defended by McCarran, later U.S. Senator for Nevada, who was convinced of Boyle's innocence. The trial revealed amazing irregularities, as McCarran's daughter summarizes some of its aspects. One of the most unique devices used by the prosecution was that the state called to the witness stand the one man who could prove Dudley Boyle's alibi, that he had left Reno early in the morning of the robbery and journeyed by automobile to Goldfield. Summerfield elicited the man's name and address and then dismissed him from the stand. Thereafter, McCarran, continually overruled by Judge George Bartlett, was unable to cross-examine the man or elicit from him the confirmation of Boyle's alibi. This would be unbelievable if it were mere news reporting. The transcript is available. Even on appeal, Judge Edward A. Ducker, who had succeeded McCarran on the Supreme Court, handed down a terribly facile decision against Boyle, who had been sentenced from 5 to 20 years in the state prison. He was released after 6 years and subsequently committed suicide. When he had been working for parole, Boyle had written to McCarran, "You know and I know that I'm innocent." This was, unfortunately, in the depth of the Depression, when everyone was desperately distracted. There was much to suggest that when the owner of the Bank of Sparks desired a conviction, it could be obtained. This is not an isolated case, but it is not the common case. The fact is still true that virtually all indicted men are guilty, and they, in most cases, plead guilty. To avoid enforcing the law, or to break down the law because of such cases of injustice, is to compound the injustice. The enforcement of civil and criminal law is in the hands of sinful and fallible men. It cannot be made infallible. To improve the quality of law enforcement, and to bring about greater obedience, it is necessary that we have more godly men. There is no answer but only further decay in any weakening of the law. To use cases of injustice to destroy the law is itself a very great and deadly act